It's for cases that come in, usually investigation cases, and in the course of the investigation, the worker is very concerned about medical conditions. They do a consult with the nursing staff, and as a result of that, there's usually the nurses go out and they could do a visit in the home, they could consult with the medical practitioner or the children's hospital and follow up, and there's a team approach to how those cases are followed up, with the nurse being a really important part of the team.
So am I to understand then, are the nurses primarily consulting on what we would call GPS cases, or are they consulting across the board?
Across the board.
I mean, I think we all realize that there are many children who come into the system because they have complex medical needs that aren't being met. So, you know, pediatricians, family members will call into child welfare agencies. And so, you know, imagine that you're a child welfare worker and you have a child who comes in because they have severe malnutrition, maybe they have type 1 diabetes, and you know, just as a caseworker, you're not going to know really very much about the medical issues and the health needs. And our nurses really have not only decades of experience in nursing, but also some of them decades of experience in child welfare nursing. So they understand child welfare and they understand nursing, and they really bring both of those things, I think, to every case. They're really spectacular, I think.
They are.
Can I ask a question then? Going back to what that was my question about nurse-family partnership and the prevention piece. So how do you connect with doing the prevention work, identifying those families that are most at risk early on, and then the connection and how that whole works as your system?
Yeah, when we identify those families, our nurse-family partnership program is not that big. We make a referral to the program. And then with the MOM program, there's now 3 zip codes, and this is actually something that's been supported through our needs-based plan and budget. There's now 3 zip codes where we think we have a tremendous amount of need for education of parents, new parents, and it's a very simple kind of program. It's really meant to educate parents on the things that they need to do to take care of their children. It's pretty basic and it's universal. And so the hope is that with the success of that program, we'll be able to expand it. And so my boss happens to be the health commissioner and the deputy mayor of what we call Health and Opportunity. That's the Department of Human Services, the Department of Behavioral Health, and the Office of Supportive Housing. So there's a real collaboration between those agencies in an effort to identify those families that are best suited for a nurse family partnership or a MOM program, universal visiting program.
What about your connection then with the school system? Because many times those school nurses are going to identify those young moms early on, the teen moms in schools. So is there a good relationship there?
I think for those of you who are not from Philadelphia, we have a pretty tumultuous situation with our school district right now. There's been a change in leadership. There's significant funding issues, and so we do have a good collaboration with the school system, and there's multiple areas that we collaborate. We have a policy group that comes together to talk through some of these issues, but I think the funding problems for the school district in Philadelphia has resulted in them trying to take a look at new priorities. And so early childhood development and early learning is a huge piece of the work that they try to do, but many of those areas have been impacted by budget cuts. And so I think we try to do the best collaboration that we possibly can, and certainly there are lots of dedicated professionals at the school district who understand the importance of early identification and making sure that those children get into a Head Start or whatever program is most important. I think the other thing that we do in Philadelphia that's really important is we use Ages and Stages, which is the mandated screen that all children in the child welfare system are required to get, and hopefully the referrals to early intervention and the follow-up to those early intervention programs make a huge difference in sending the right children into the right services at an early stage.
And I have one comment and a quick question. My comment is, you know, Philadelphia really is paving new roads here for Pennsylvania. And Annie, your leadership has been amazing. I recognize not everything that you all plan to do will succeed, but I think a lot will. And the medical model is a piece that I think is critical. There's no reason that as we move through this, that other counties cannot adopt this kind of a model. I appreciate that you're taking the initiative to do some things that are thinking outside the box and very different for the child welfare system. So I needed to say that to you. And our role is to make sure that you succeed. My question for you, and I'm really trying to think this through, so I hope you can help me. As you, in your testimony, you talked about sexual abuse and that we should be involved with all persons without qualification. My concern with that is that the child welfare system was always created around the family model, which is how do we help families? How would we do this? What are your thoughts about expanding it to that? How would we succeed? Would it be too overwhelming? Those kinds of questions.
So it's funny because in my notes, my staff who helped me prepare my testimony, they kept putting in here, caution Annie, this might lead to more referrals. Caution Annie, this might lead to more referrals. And I think this is fundamentally about prevention. If we don't provide support to victims of child sexual abuse, we're going to see them later. We're going to see them later in the adult prison system. We're going to see them later in the mental health system. We're going to see them later in the homeless system. And so for me, it's about making sure that children who are identified as victims have the treatment and the support and the help that they need to heal.
Okay, and as a follow-up to that, and again, my concern's to capacity. It's not whether it's right or wrong, because the more we get involved in the right kinds of cases and protection cases, the better we can serve the population. But my question would be, the way it's law enforcement is set up today, each department, I know there's been money issues, but each district attorney's office has a victim witness department. And correct me if I'm wrong, but the victim witness, I thought, and I recall from my many years ago in the DA's office in the 1990s, really was to ensure that those connections were made for those children who were victims of sexual assault. Now, maybe the problem is, do all cases actually, they do get to the DA's office because through Childline, we send them, but do they have the capacity even to look at all cases?
But wait, make what connections?
For victims, for services. Because what you're talking about is the safety and well-being of that victim, correct?
Correct.
And I get if it's a family member, we need to provide services to that family. And again, I'm not saying I'm right or wrong, I'm just trying to figure it out. Then as we look at victims who are not victimized by family members, would it not be for the criminal justice system to ensure that those children are connected with appropriate community services? And
So we have an expert in the room on this. I'm looking at Jim Anderson, who's not paying attention to me right now. What I would say, and I'm going to look at him for nodding or shaking his head, you're wrong, Annie, is that those victim services have been decimated by budget cuts. And what I would say is that many of those systems rely on our referral for treatment. So my guess in Philadelphia is that many of these cases get referred to us, but for the reasons that Dr. McColgan talked about, the waiting lists are long, and children and adults in many instances do not get the treatment they need in a timely way to really deal with the traumatic impact of what's going to all come later. So I think it's about integration and collaboration, but those are not services that are readily available in the community, particularly in Philadelphia.
so do you all provide in Philadelphia the trauma services to victims of sexual assault? Or it's done through your CAC? How's that done?
There's different ways. So one of the things that Chris Kirshner, who's the head of our Philadelphia Children's Alliance, is trying to get a federal grant to actually provide the treatment in our co-located facility. We also contract with JJPI, which is does provide some trauma-informed treatment for both victims and perpetrators of sex abuse. The behavioral health system provides some stuff. We provide some for our delinquent youth in a program that we call DelStar. But there's just not enough services out there, and I do think that the victim witness folks in Philadelphia probably refer to the same resources that we have for our kids.
I would suspect that that would be so. Jim, you can go beyond nodding.
Hello. I think the victim services funding, with the exception of victims of juvenile offender funding, I don't think has been cut. I guess I think one perspective on the issue of who the perpetrators are of child sexual abuse in most cases. If you look at that, frequently family, extended family members, or what has resulted because of a lack of supervision. So as I'm thinking about this, if you look to expand who would be a perpetrator in sexual abuse cases involving children, I'm not so sure you would significantly expand what the child welfare role would be. That just in a very general sense, but I do think that it's very important to look at that.
We do see a fair number of young children who are sexually abused by schoolmates and other older kids, and that doesn't necessarily fall into the CPS model or into the child welfare model. But as pediatricians who are sometimes seeing these children for medical care, you really want to get them into the child welfare system, not even so much for the child who was victimized, but for the older child who was the perpetrator. So, there is some, I think, good reasons to get some child welfare involvement.
Yeah, and even on some of these cases where we offer services anyway. I mean, when it comes to our attention in our purview of the investigation, we try to offer up services, even if the case isn't except for service, because there's no real safety threat in the home. There are prevention services that we try to refer that child to.
I was gonna say, sorry, go ahead.
Go ahead.
Oh, as a pediatrician, I absolutely agree with Cindy insofar as I think the goal of CPS is the family. And I think that sexual abuse in one child occurs independent of the family, even when the perpetrator is a non-family member, is not really the case, because that whole family is being affected by that child, and the way the family responds, whether they bring the child to treatment and the other siblings, are so intricately related to whether that child recovers well. So I think from that argument, I think expanding that perpetrator allows you to get help for that family. But again, it goes back to counting. Should the child not be counted in the system as being sexually abused because the perpetrator doesn't meet the narrow definition? Because again, then it doesn't allow us to say how many children are victims, because in a sense, we're all responsible for making sure that all children are safe from sexual abuse, regardless of who the perpetrator is. So whether or not the services are given through CPS, I think it's wrong to blind CPS to those children, which is kind of exactly what you're saying.
And I wonder if I could just get back to something that is related to that. And I almost want to say, we're not even going to acknowledge that that's so anymore, because we're going to bloody well change it. It's just absurd. And I know the criminal side, not particularly the Child Protective Services side, and I am just, it's somewhere between horrified and intrigued. You have a child who is obviously the victim of some physically intended injury, or we'll put intent out. It's a physical injury. It's not an accident. But you can't tell whether it's mom or dad or uncle or whoever, multiple adult candidates, so it's unfounded. And the kid goes home. There is no ability to say, and if you want to say, as a matter of fault, moms are always at fault to protect the child. She's not being able, she might not have even thought of doing it herself, but she can't protect the child. She can't give it a safe home. So we're going to Plan B. That doesn't happen.
So it does. The facts of this case are pretty complicated and difficult. Without being able to identify who the perpetrator was, we put a service in the home called In-Home Protective Services, which is a really intensive safety service And it was in the home, I think, for maybe 18 months before the child was returned. And mom and dad did all the things that they were supposed to do. And that's the perplexing thing about this work and the difficulty for the workers. You know, they're expected to be able to tell fortune tellers.
Sure.
They do the very best job they can with the facts that they have at the time. And at some point, when families do all the things that they're mandated to do in the family service plan, and in this case, it was a court order that sent the child home. So, and judges try the very best to make the right decisions given the facts that are presented to them. And so sometimes bad things happen despite all of the very best of intentions.
Yeah, well, that's one of the things that we all have to identify, and there's such a, I think it's one of the wise things about the legislative action that created this panel, as opposed to just having people dump legislation in willy-nilly. So yes, that's a reality, but, okay, I think that covers it.
Can I make a couple of comments? In my position at the district attorney's office, I supervise our victim witness program, and my understanding is similar to Mr. Anderson's, that other than the money that's been cut for juvenile justice victim witness, the rest of the money is federal money, and it is in place for referrals and for handling victims as they proceed through the criminal justice process. But one of my concerns, and I just have to voice this, and I think I'm a little bit on the verge of feeling like Bev, is that having children and youth and families investigate child abuse cases in all situations will lead to two parallel investigations. And I think police officers, unless it is a family issue, police officers, that it goes back to, I guess, that concern and that the pooling of the resources and the need to complement each other and communicate. I'm not sure that we're going to be achieving much more by requiring caseworkers to be handling all investigations involving sexual abuse. If you're proposing that, in fact, children and youth should be involved to the extent that families need services, I understand that and I accept that, and I think that they could work with the victim witness department if there is an active criminal case going on. But if you're proposing that caseworkers be investigating cases even in situations not involving a family or household member, I think then you're going to have concerns from law enforcement about stepping on each other's toes and, you know, who does what and who's going to go take the statement from the defendant in prison, and is he going to be Mirandized, and is that statement going to come into the criminal trial? You're going to have a lot of other issues that we're going to be opening up. But if you're proposing that it remain more or less a service providing means, then I can understand that and accept that concept. I just can't see investigators working in a parallel track for every single case.
So we are proposing that we do all the investigations, and many of these cases are where coaches or church folks are in a role of protecting the child, and they victimize that child anyway. And we believe that there's an important role for child welfare in investigating those cases. I will say that I don't believe that we conduct those investigations with a parallel process. There's incredible collaboration with the Special Victims Unit of the DA's office on all of these cases. And we have special sex abuse investigation units where our workers are actually trained, and they are some of the most rabid child advocates you could ever meet in your life. And this is what they do. This is really important work to them. And the relationships that have been built between our staff, PCA, the Special Victims Unit, you know, police officers, detectives, and the district attorney's office is what I think will help make those investigations more successful. And there is definitely collaboration that would be required to be successful. But the more those relationships build, the better off the child is going to be at the end of the day.
But again, it sounds like you're referring to things that are happening now. So you are referring to perpetrators that are defined by statute to be included in CPS. But I think what Bev was commenting on something.
A stranger.
Right.
Which I believe the child does need supports and services, but I am concerned about the same thing.
So, I mean, at the risk of expanding and giving more work to my staff, I just think it's the right thing to do. I think our job is to be protectors of children. And when a children is, I think sometimes it might be even more traumatizing to have a stranger who you don't know who that person is, and there's no closure for that victim, and the fear of somebody coming back and hurting them. It's even more important for us to try to use the skills that we've built in investigating these kinds of cases and the specialization that we have to try to help the children get through the trauma of that experience.
But wouldn't a unit that is geared towards providing services and not investigating be able to accomplish what you're suggesting without doing an investigation, is what I'm getting at?
Perhaps.
Well, on that note, I think we will conclude our morning's testimony. Thank you very much. And we will now be in recess until 1 o'clock.
Do you see that lady that was over here? That's Leroy Irvis's daughter. You thank the Office of Children, Youth, and Families.
Oh, there you go. Well, I
We are
don't know
taking
that
care of lunch for today.
I see. Well, and
Heather Holman up there, who helped coordinate with Vicki and Mary.
there you go. Well, our thanks to the Office of Children, Youth, and Families then for our repast. And we've tarried just a little bit, but I think we're drifting in here. And our next presenter is Mr. Frank Cervone, who is the Executive Director of the Support Center for Child Advocates. And Lord knows they can use support. Mr. Cervone.
Don't listen to those advocates, they get a lot of support. Chairman Heckler and members of the task force and staff, thank you for the opportunity to present today. The Support Center for Child Advocates is Philadelphia's lawyer pro bono program for abused and neglected children. At Child Advocates, we work to change the story for children. For 35 years, and indeed we celebrate our 35th year tonight with 900 of my closest friends, God willing. We have offered the skills and dedication of lawyer social worker teams. We represent more than 850 children each year, including several of the kids mentioned by Doctors McColgan and Scribano this morning. While our direct service work is Philadelphia focused, we work with partners across the Commonwealth of Pennsylvania and the nation on the development of effective policy and practice for vulnerable children. We attempt to offer a balanced and candid and constructive assessment of what our children need and of how we're all doing for our kids. I'm assisted in this presentation by the work of Kathleen Palm and our colleagues in the Protect Our Children Committee, the POC, we like to say, Pennsylvania's statewide coalition of advocates, physicians, and service providers joined together in coordinated strategies to prevent child abuse and to achieve targeted child welfare reforms that are child-centered. We look forward to working with the task force in the coming months to identify priorities and advance reforms that will, consistent with your legislative charge, restore public confidence in the ability of the Commonwealth to protect the victims of child abuse. I want to be clear, however, that the positions presented today are not those of the POC or its other members, except as individual or organizational members of this coalition may agree with them. They represent only the positions and recommendations of the Support Center for Child Advocates. I did not vet my testimony in its final draft, though consulted extensively with folks from around the state. We focus today on issues related to the definition of child abuse as found in the Child Protective Services Law, or the CPSL, and is experienced in the practice of lawyers and advocates, physicians, and others involved in child welfare in Pennsylvania. As you've heard this morning and prior, physicians and others have noted troubling gaps in CPSL definitions and in children and youth investigative practices regarding the evaluation of injuries, the assessment of pain, the approach to cases involving multiple potential perpetrators, and incidents of abuse in schools. During my testimony, I'm going to try to explore some of those gaps, examine what types of cases are being overturned upon appeal, and how this process in turn influences decision-making at the county level. I mentioned here, but I'm probably not going to explore in depth the rates of abuse and investigation, except if we want to talk about whether this or that change is going to increase or decrease reports, as you explored this morning. And lastly, suggest some changes to current laws relating to the definition of abuse, to investigation and service, to assist you as you consider recommendations to make to the General Assembly and the administration in this important task of reform that might make our world safer for kids. I thought we might look at some texts because though this, of course, is something only a lawyer would say, texts are where the action is. Okay? By and large, I will not be addressing two favorite topics of mine, the duty to report suspected abuse or the creation of a children's ombudsman. As I understand, these may be addressed at forthcoming hearings or elsewhere in the legislature. Of course, on this and other subjects, I'm glad to answer your questions. Most importantly, while we want to increase protection and safety, and in fact, we fear that we're missing some kids who we might otherwise get into the fold, our goal should not be to increase the number of children who are subject of reports of abuse, nor is it to increase the number of kids who are in protective custody or foster care, or the number of adults who inappropriately, or to increase the number of adults that have child abuse records. Our goal is and should be to ensure that reporting occurs when needed, and that reporting is more straightforward, and that not more or fewer kids, but that the right kids are getting the care and protection they need. It's a fine motor skill, and that's the end we should be working on. So we begin with this topic of non-accidental injury. Pennsylvania has long recognized that accidents should not be considered child abuse. And so the core definition of child abuse in the CPSL distinguishes accidental physical and mental injury, and I've presented the text. As suggested by the Commissioner Ambrose, this task force in the General Assembly should review the consequences of the 2002 PR decision, the resulting statutory amendment, and practical implication of this term accidental as it's being used by investigators around the state. You may recall that PR is known as the belt buckle case. A mother attempted to discipline her daughter with a belt. The child fled and the mother pursued. When mother swung the belt at this moving target, the belt buckle struck the child in the eye, causing an eye injury which necessitated hospitalization and surgical treatment. You get to severe there, right? That's hospital surgery. Concluding that the injury to the child in PR was both unintended and accidental, and that the mother did not commit an act of child abuse, the Supreme Court applied, and they used this phrase, the criminal negligence standard. So the line between abuse and accident after PR is now whether the person acted without sufficient regard to a substantial and unjustifiable risk. That standard gets codified in 2006 by the legislature, and so it's embedded now, hardwired into the act, an injury that is the result of an intentional act that is committed with disregard of a substantial and unjustifiable risk. We highlight today the unfortunate blurring of the boundary between accidental injury and inflicted injury. Query, should PR have been decided differently? Is not the swing, and in full disclosure, Mr. Koudelakis and I think, came in on one side of that, did we not, in filings before the court? So I'm just remembering as you're nodding, we were in that case as amicus, I guess, right? Is not the swinging of a belt with a buckle itself a reckless and dangerous act? Using the yardstick of both civil tort and criminal negligence, wasn't this injury foreseeable? Most importantly, we believe that cases are being unsubstantiated at both the investigative and appellate stages based on the misuse of the definition of non-accidental, where injuries which were not intended but were clearly disregarding risk. That is, the rule in our experience is you had to intend to cause the injury to the child, and anything less is an accident. That's not what PR even meant, even if you thought PR got it right. We recommend that use of an implement to inflict injury, such as a belt, switch, electric cord, be characterized in law and practice for their foreseeable consequences. It doesn't have to be per se abuse. Guys like me and others might actually want to have use of a belt as per se abuse. We don't have to go that far, even. to characterize it as foreseeable. We further recommend the DPW and the county agencies be required to include information on cases of inflicted injury that are dismissed or unsubstantiated in their respective annual reports. We ought to be working with data, and this will be a recurrent theme. We make a lot of these judgments without any good knowledge about what's really going on. And that just seems silly in a world where we're collecting so much data. Let's collect the right stuff. Perpetrator undetermined. Child abuse cases, child abuse investigations occasionally encounter the problem that Dr. McColgan recalled this morning, the problem of multiple undetermined perpetrators, where despite finding credible medical evidence of inflicted injury, child has severe head trauma, baby with shaken baby and the sequela. Despite this credible evidence, the involvement of multiple parties as having been responsible for the child's care and well-being during the time period that the injuries occurred preclude the designation of one of them as the perpetrator, right? So the leading case has 4 people in sequence, had the kid at different times, mostly out of the presence of each other, right? Mom to dad to grandmom to somebody else, and eventually somebody figures out the kid has brain damage, right? On TV, you put those 3 or 4 people in 3 or 4 different rooms, and gumshoe investigators shake them down until one of them owns up to it or dimes out the other one. That's just not the way it works. Where there's more than one person responsible, can either or both of them presume to be the abuser? Well, the doctors would love for that to be the case. Many advocates would love for that to be a case. It's one of you. We're going to make all of you the abuser. Okay? The due process isn't going to get us there, and we're going to look at that. So the leading case is BB versus DPW. In this expungement case, the father had been found by the ALJ to be one of 2 persons caring for his 2 children when they were injured. The Commonwealth Court focused on the language of the statute that looks to and for a single perpetrator. So you see it quoted here. It's a bit technical, but I'll take you down halfway. The General Assembly, in setting forth the presumption that if you have the kid, you're responsible for the injury that occurred during your watch, the statute refers only to the parent or other person responsible for the welfare of the child. The clear use, and we quote, the clear use of the singular tense cannot be read as an accident and cannot therefore be read to apply to any situation in which the presumption is sought to be applied to more than one person or parent. So while a change in the statutory language, for instance, from singular person to plural persons, might cure the facial defect highlighted in the case, we must acknowledge, as the court did also, that imputing a degree of guilt or causation to more than one actor may have logical and due process problems. That is, having 2 possible suspects does not get the investigation sufficiently close to the one who actually did the deed. Note, this should be distinguished from a case where there's substantial evidence that both and each of them committed the act or the omission. However, this should not end the discussion, as there are implications that must, and I must say, I do feel a bit frustrated as a drafter that I don't feel like I've been able to cure this myself with my pen, and I feel like some creative writer might cure this problem in the text, or maybe relook at it entirely differently, as speakers presented earlier today. So there may be some textual answer on its face. But there are other kind of systemic responses that I think would make the system more protective in these cases. We should consider when and whether and how these particular unsubstantiated child abuse cases are referred and monitored for service, how they're recorded in some official way for statistical purposes, and so on. And so we offer 5 or 6 specific solutions that we might expand upon at some point. First, mandatory MDT review. The county team should review and report if a case is unsubstantiated or otherwise unfounded due to a multiplicity of potential undetermined perpetrators. These difficult cases should be studied with heightened scrutiny. Second, maintain some record of these several possible perpetrators. While there's a compelling evidence of possible involvement in where there is compelling evidence of possible involvement in an abusive act, but the finding is nonetheless inconclusive due to this multiplicity of potential perps, some form of registry may be salutary in the event of subsequent similar situations. Now, we have to acknowledge all sorts of civil liberties issues around keeping the names of people for whom there's been no finding. And I'm aware of that. At the same time, you have a kind of where there's smoke problem. The statute today and the regulations allow for the preservation of unfounded reports for a period of time, just so that the subsequent report that comes in with that time might be connected to the first one. So it's that construct we're talking about. We clearly would have to unpack it. Perhaps more importantly, track the kids. Where there's compelling evidence of child abuse, but the finding is nonetheless inconclusive, as we stated, the children should somehow remain on our radar in case planning, in services, and of course in statistical recognition. There was conversation in the earlier session about linking, I think it was Dr. Christian's, you have these sequential diagnoses, none of which entirely get you there. But if the doctor had all three of those diagnoses or reports in front of them, they might know a lot more about what's happening today. Fourth, provide services to the child. The except for service decision, and this is a term of art in the business, it's in the regulations, it's the way the children and youth, it's the on-off switch for children and youth service. The except for service decision should be separate from the identification of the perp, and thus services should be provided as needed in response to incidents of abuse. Today, we don't have a perp, we close the case, family moves on. Sometimes the family still needs service. Right? But in this world of limited resources, we're not getting to every family we might. They walk, we move on to the next case. Right? We're all responding to our respective priorities, and the child comes back later. Finally, again, get the data. To facilitate further study, the department and the several county agencies should be required to include information and data on the number and the facts of cases that are dismissed due to perpetrator undetermined. The next major category of definition that we present, you've heard about it this morning, is the severe threshold for injury and substantiation. Others have called this to your attention. The physicians who testified today, including task force member Dr. Berger, who previously presented compelling case narratives and photographic evidence, eloquently demonstrating that the use of the term severe pain in the definition of physical abuse cases is having problems. That either the doctor's not being believed when they say it was severe, or somebody's not finding it severe because the kid's too young, and well, what do we really know about what she felt, and so on. Let's unpack the statute. The statute uses severe pain in the definition section as one of two thresholds for finding that the child's been physically abused. It's called non-accidental serious physical injury. And you see them, an injury that causes severe pain or significantly impairs a child's function, either temporarily or permanently. So there are countless examples of these colloquial accounts of workers not finding severe pain in otherwise horrendous fact patterns and victim presentations, even when the examining physician opines that pain was present. Examination of practice in the counties would likely find that virtually no matter what the report of the victim child or that first person witness was, absent bruising, there will be no finding of abuse. This is in fact the way it is. You hear this over and over again. No bruise, no abuse. The use of the term severe thus is problematic. I'm not sure we need to get rid of the term, and there is a certain theory about that. We then have to figure out what's the line going to be. Is it all pain? Can't be that. We'll have 10 times the cases we have today, right? Is there some other measure we ought to find it? I think we might unpack how we get to severe as a pathway. So we urge the amendment of the law to allow both objective and subjective assessment of the degree of pain experienced by the child victim. A child-centered approach in the statute and in practice would take into consideration some of the following. First, an individualized assessment of pain. Now, pain's always subjective, right? I think.
Correct.
We can say that. Pain is always a subjective account. In addition to the observation of bruising and impairment, the law should sanction a subjective assessment of pain by the investigator or the physician, including consideration of the child's self-report. And so you have even in the, I think it's the FB case, it's either BB or FR, the court actually looks to the pain scale that doctors use. On a scale of 0 to 10, could you characterize your pain? We might use what's known as the Wong-Baker faces. Smiley face, less than smiley face, crying face for a young child. And then that becomes evidence. It ought to be allowed to be evidence in court, and it certainly ought to be information that the investigator uses when she's making her determination. Other indicators of pain and injury. The law should recognize and sanction consideration of other, in a sense, indicators. So, simple example, the court in FR noted that the investigator had noted the child reported not being able to sleep on his backside for 3 days after being beaten. Should be enough. Should certainly be compelling and convincing to the investigator. Most importantly, the inquiry should be child-specific. The law should ask, did this child experience a serious physical injury or severe pain? So the relevant factors might include pre-existing medical conditions, particular vulnerability, age of the child, certainly developmental delay, perhaps a history of injuries. Right? We should be asking about this kid, which of course relates to, doctor, what did you hear from this child? Now you're back to the doctor and giving her some credibility and support. Inflicted injury should be different. Dr. McColgan taught me this. Injuries and pain may not tell, degrees of pain may not tell the whole story. While a cigarette burn may typically be evaluated as a second-degree burn, we know that you get second-degree burns from medium sunburn, right? Sunburn isn't child abuse. Cigarette burn, oh, is that the kind of pain you had? It's like child abuse? It's like your sunburn you had last week? Sorry, that's not child abuse. You could see an interview going that way. Can you tell me what it felt like? It felt just like the sunburn I had at the beach. I guess that's not enough. You got over that, didn't you? The fact that the injury was inflicted should be explicitly relevant under the statute. Use of implements on children. Most child-serving professionals and many parents agree that corporal punishment should be avoided in parenting practice and even banned by law. Now, I know this topic is controversial in various cultural and religious communities. As is often said of the efforts to reform the Federal Social Security Act, taking on corporal punishment is the third rail of child welfare advocacy. Nobody wants to go there. So I want to offer you a kind of medium ground where you might stand. There seems to be no reason in law or practice to sanction the use of an implement or a weapon on a young child. We recommend that use or threat of use of an implement or weapon on young children be established as child abuse per se. While we, as an office, my staff went nuts when I made this suggestion, I'll be really clear with you. While we're reluctant to suggest that any threshold that might imply approval of corporal punishment above an age, we don't mean to say that, but at least, for instance, the age of compulsory school attendance might be a rational basis of distinction, because prior to school attendance, no one's watching the child. I think we'd get some traction there among parents across the state and in the legislature. Lastly, bruising should be sufficient but not necessary. So the law should include an explicit provision that physical evidence is sufficient sufficient but not necessary to support the finding of child abuse, mostly if other substantial evidence exists. That is, bruising or other physical indicators should remain sufficient, but the absence of bruising should not be dispositive in the negative. No bruising, no abuse, shouldn't go that way. Under the current definition includes severe pain, case law supports the notion that severe pain may be found even without the testimony from either the victim or a medical witness. Regardless of the absence of testimony, photographs depicting injuries may provide substantial evidence to support a finding that the child suffered severe pain. And the distinction there is, so the photo's got a black and blue mark on your arm, that's not going to be abuse. You're going to need some story about how the mark got there. We were talking at lunch. My little brother hit me with a Tonka truck. Not abuse. My mom threw the Tonka truck at me because she was mad. Maybe abuse, right? But the photograph that, per se demonstrates child abuse, right? The severe injury to an ear, demonstrating the child was clearly whacked so hard that the ear was bloody or worse, right? There's a case. This distinction should be codified in law. School abuse. The CPSL sets forth a largely separate path for the definition of abusive events. Note, the term child abuse isn't even used. It's not child abuse in the schools under the statute. These events that occur in schools, including different definitions, different types of evidence that may be considered, and different response mechanisms for both reporting and investigation. From my experience training on the Act for many years, and I believe for those who must administer the Act as mandated reporters and as investigators, this alternative path is confusing to almost everyone who engages the subject. The CPSL provides the following definitions and references to students in public and private schools. And one might just track, we don't need to necessarily do that here in great detail, what child abuse is under the Act, what school abuse is, what the reporters do, and so on, side by side. And I've highlighted them here. I want to flag the person responsible for the child's welfare. This is where the deviation starts, right? The classic definition of one who is eligible to be a perpetrator is a person who's responsible for the child's welfare. Parent, caregiver, child over 14, living in the same household. The term does not include a person who is employed by a school. So there's the carve out. There's where it starts. And we kind of back in when they are attended to by defining what a school employee is and then saying what abuse is in the schools. And there's only two types: serious bodily injury and the other one. Sexual abuse or exploitation. Serious bodily injury or sex abuse, right? There's no emotional, there's no neglect, there's no imminent risk, just for starters. And then you see in section 6352 and 53, the investigative and reporting pathway and how it's different. So in the rest of the world, you suspect abuse, you call Childline or your county agency. They do an investigation. If they find a certain crime's occurred, they tell the cops. Here, this person in the school tells their administrator. Their administrator may or may not do an investigation. They're not supposed to, but in fact, they probably do. They may or may not call the authorities. They're supposed to call their local cops. Now, I like local cops. My wife is a township supervisor. She signs the paychecks of local cops. I don't want them investigating child abuse. Back to the discussion from this morning about whether this should be done by the police or by CPS. We like forensic interviewers, people who are really trained to do this. And maybe folks who have been through the Child First program in great detail and have demonstrated some skill. But the pathway for the schools, well, just the fact that it's different is borders on absurd. It's confusing, and we've noted a number of the textual problems that I've highlighted here. The difference between serious bodily and serious physical, silly, stupid, just stupid. I'm not going to go through it. Reporting requirements, right? The two pathways for reporting. There was probably some rationale. Lore has it that the state teachers' unions wanted a different response. I've never got that authoritatively. I'm sure they would speak to you at great length about this subject. The background checks are really what's important. To the extent that you want a registry that has everybody in it that's supposed to be in it, and again, it doesn't have to be overly broad, but it needs the people in it we think supposed to be in it. Coming out of the schools, you might not get in the registry because of the different definitions. So we recommend review of this historical rationale for the different statutory schema, with our presumption being that the distinctions are invalid and ineffective and troubling. Last big topic, who can be a perpetrator? Like many states, under Pennsylvania law, there are limitations on those who can be considered a perpetrator. This is significant in that abusive acts against children committed by persons not qualifying by such characteristics will likely not be investigated by the Child Protective Service, and as perpetrators, they won't be listed in the registry. A baseball coach, member of the clergy, family member not living in the home, these are all trusted souls. They gain access to the child by virtue of their relationship. They are not to be considered as perpetrators of child abuse under the law unless they're in a caregiving relationship. So we need to ask ourselves why that is and whether it remains appropriate going forward. The child who's been beaten or sexually abused has suffered no less trauma, who's been taken advantage of by virtue of that trusting relationship is no less a victim, just because uncle is visiting from another state, or is a parish priest, or is a community Little League coach who inflicted the abuse. In recent months, I can tell you, I've had dozens of conversations with knowledgeable professionals and a few legislative staff about which, if any, of the Penn State officials were mandated reporters, and whether Mr. Sandusky is even covered by the law. It's the topic of the day. We need to eliminate that confusion. The statutory definition of perpetrator should likely be expanded or clarified to include, at a minimum, family members not in a caregiving role, and perhaps other persons who are in relationship to the child, and perhaps even unrelated persons where there's substantial evidence of abuse. But I know the unrelated person class really is the most controversial of those three. And I think they might reasonably be approached separately. You got family members and so on. General Protective Service and differential response. The CPSL provides for general protective services. There's a definition, but it doesn't work very well. I was actually moved by the comment of a member of the panel this morning who said, well, that's a case we would call a GPS case. It seems rather absurd that in this business of texts and definition and intrusion in the family life, we would all be allowed or caused to have our own definitions of a category of intervention. But that's in fact the way it is, because you can't tell a GPS case by looking at the act, and you sure can't tell it by looking at two counties in comparison. There's some coincidental overlap, sure. There's lots of cases that are reported in this list and that list, but it's a mess. And you've heard that a number of times, I know. Most child welfare experts and advocates agree that a, quote, differential response is appropriate to distinguish cases involving child abuse from those situations that do not qualify as child abuse under the law, but still need some form of either protective intervention due to safety threats or supportive services due to family needs. When it comes to interventions about child abuse, we should be clear that too little distinction can be problematic. If the only tool you have is a hammer, every problem looks like a nail. Some families are healthy and safe enough to merit voluntary supportive services. Other children need a far more intensive, even intrusive approach. And of course, one of the hard tasks in child welfare work is to distinguish the case that needs the hammer from the one that needs the helping hand. And that's what we mean by differential response, kind of as a metaphor. But what we really mean is programs, services, and protocols, and this is where we're kind of lacking. In our work, well, I'm going to skip down to what we have in Pennsylvania. It is unclear whether we have a differential response in Pennsylvania at all. We have an array of services. We have lots of folks getting voluntary services. We have lots of folks getting quasi-voluntary. That is, if you don't do it this way, we're bringing you to court. There's a lot of that happening without it being said, kind of a lot of coercion of families. In the safety model, but we have no solid data on these caseloads or their services. In the safety model of practice, which is the watchword of the day and one which I support, the absence of safety threat gets the case closed. While I support the focus on safety, differential response should provide services before the case closes. As we saw in our own Philadelphia Child Welfare Review panel, we need to make some choices about where we put our resources, or we end up being all things to everyone, and that's just as bad a problem. You heard from Dr. David Sanders at the last hearing that we're a statistical outlier in the investigation and determination of child abuse. It's time we got to the bottom of that, rather than back and forth about, well, this is what we mean, and this might be the answer for it, and so on. My colleague, Kathy Palm, has provided research indicating that the Federal National Quality Improvement Center on Differential Response, 17 states have a formalized differential response program. And there are core elements. Now you can go down the list. Do we have these? Some say yes, some say not. You can't find it in one place in the Act, and you ought to be able to. 2 or more discrete response pathways. They should be formalized in statute and protocol. The pathway should be assigned based on an array of factors. The pathway assignment can change based on risk level and other problems. The services are voluntary, not coercive. Families are served in a non-investigative way based on assessment, and no perpetrator is recorded. That's what the world means by differential response. That's not how we're doing it, folks. And so the POC has offered, in the bucket list that you were previously provided, a comprehensive set of recommendations on this topic, which I've reiterated for you in my prepared remarks, and I don't think I need to read for you. In summary, the CPSL and the Juvenile Act set forth a regimen of response and services under the rubric of GPS cases that need some form of intervention but do not qualify as child abuse. Little data is collected, and the practices around the state vary from county to county. The emerging work on evaluating and improving the quality of a differential response must be an even greater priority. And what study, as I've touched upon, I think we can learn about these differences. There remains one, in a sense, by number smaller topic, but it's obviously of concern because any kid caught in this might be. And it's the incident that occurs out of state. A thankfully small number but troubling set of cases seems to elude review. The child's allegedly abused in a foreign U.S. state, I'll call it Michigan, which is the case that I had just last month, and then legitimately the child's brought to Pennsylvania by a caregiver with the consent of caregiver number 1. But because the abuse is reported to have occurred outside Pennsylvania, no report is taken, no investigation is commenced. As well, because the child's no longer present in the foreign state, the investigation isn't going to happen there. So a kid comes to our door with his dad, a dad comes to our door with his kid because we've got support on our wall, and he's looking for child support, and he thinks we're going to help him get child support. Sorry, we don't do that kind of support. And he starts talking, so I interview him because I was around, and he shares that his son had been hit in the neck by his mom. Kid's sitting there. I just done testimony on whether Joe Paterno was a mandated reporter, so now I'm particularly hyped on this question of whether I'm a mandated reporter. So I talked to the kid. Sure enough, he's got this big black and blue mark on his neck. You know, kind of looks like a hickey, if you'll pardon the expression. And I interview him alone. Mommy did that. She was really mad at me because I got in the tub when I wasn't supposed to. I'm a mandated reporter at that moment. I pick up the phone. I call Philadelphia. They say, sorry, happened in Michigan. I called Michigan. Oh, they should have taken that case in Philadelphia. We'll do something. Sure enough, 20 minutes later, supervisor, can't do it here. Child's not here. Call Harrisburg, child line. Have a wonderful worker, talks me through and points me to this statute. This statute doesn't answer that question. This is a gap that somebody ought to close. It's downright silly. This kid should have been interviewed. Make a report and take it from there. We'll go find the perp wherever she is, kind of thing. Okay? In summary, there's good news. Abuse numbers are down ever so slightly for the last 3 years. Both the number of reports and the number of substantiated cases are down, ticking down ever so slightly. We'll take anything, right? It's the right way for the line. I'd like to think that prevention efforts are working, but we can't really tell, right? The bad news, unfortunately, in this business, most news is bad news. There's too many false negatives. There's at least the occasional false positive. Still way too many abused kids. Intending no disrespect, and that's what we have to be about. We have some heroes today and some villains, and just in my remarks I come to the heroes that I might not otherwise, but I just want to mention we got here today because of just a few people. And 2 of those are heroes. I want to recognize the vision and the zeal of Kathy Palm in coming forward repeatedly to this legislature and this administration to convene a task force. She is truly one of the heroes for children. And as well, the courage of Senate staffer Vicki Wilkin, who's hiding around here somewhere, who really carried this flag in the Capitol building. On the undercard of this fight, Penn State and abuse by priests gained the world's attention. to which I am moved to observe to the world, where have you all been? We've been working for years to gain this kind of attention, and just a few very tragic and fairly extreme and, well, quite frankly, odd cases got us here. But now we're here, right? The doctors are here,